You think evicting a tenant is a quick fix? You're wrong. In California, a single eviction can easily consume 45 to 90 days of your time and set you back anywhere from $5,000 to $15,000. That's not a hypothetical. That's money bleeding from your bottom line directly into legal fees and lost rent. But here's the brutal truth. Most of these financial hemorrhages are entirely preventable. You just need to understand the battlefield before you engage. Before you even think about court, you must navigate California's strict notice requirements. This is your first and most critical step. Get it wrong, and you've just handed your tenant a free pass to delay the entire process, costing you more time and more money. For non-payment of rent, the standard is a 3-day notice to pay rent or quit. This notice must be meticulously prepared, stating the exact amount due, the names of all tenants, and the payment methods accepted. It must also include specific language regarding the tenant's right to pay. If your property is under rent control or subject to AB 1482, statewide rent control, you might need to include additional disclosures or provide a longer notice period, like 60 days for a no-fault eviction. Here's the math. If you serve a 3-day notice on a Monday, the 3 days typically expire on Thursday. If they don't pay, you can't file your lawsuit until Friday. Every error in this notice, every missing detail, can be used by a savvy tenant or their attorney to invalidate your notice, forcing you to restart the clock. That's another 3 days, 30 days, or even 60 days of lost rent, minimum. A single mistake here can easily cost you $1,500 to $3,000 in lost rent and potential refiling fees before you even step foot in a courtroom. Now here's where it gets interesting. Many landlords attempt to draft these notices themselves. Don't. Your eviction attorney will charge you significantly less to draft a compliant notice than to fix a defective one you've already served. Once your notice period expires, and the tenant has not complied, you can initiate an unlawful-detainer (UD) lawsuit. This is the formal legal action to regain possession of your property. You'll file a summons and complaint with the superior court in your county. This document outlines your case, demands possession, and often seeks back rent and damages. After filing, the summons and complaint must be properly served on the tenant. California law requires personal service whenever possible. If the tenant evades service, you might need to resort to substituted service or post and mail, which adds complexity and time. Consider this. After you file, the tenant has 5 calendar days to respond if served personally, or longer if served by other methods. If they don't respond, you can request a default judgment. However, most tenants, especially those with legal aid, will file an answer, denying your claims or raising affirmative defenses. This immediately escalates the case from a simple default to a contested eviction. A contested UD lawsuit adds weeks, sometimes months, to the timeline. For instance, a basic, uncontested UD might take 30 to 45 days from filing to judgment. A contested one with discovery and motions can easily stretch to 60 to 90 days or more. Each additional week you spend fighting in court translates directly to another week of lost rent, typically $500 to $1,000, plus potentially thousands in additional attorney fees. But wait, there's a catch. Even if you win a default judgment, the tenant can often file a motion to set aside the default, claiming they never received the notice or summons. This means more court time, more legal fees, and more delays. If the tenant files an answer, your case will proceed to a court hearing or trial. Judges in California are highly sensitive to procedural errors and tenant protections. They are looking for meticulous adherence to the law on your part. This means your documentation must be flawless. The lease agreement, the notices served, proof of service, rent ledgers, and any communication with the tenant. Any ambiguity or missing piece of evidence can sink your case or force you into a settlement you don't want. Judges will scrutinize your notices for correct dates, amounts, and proper language. They will examine your service methods to ensure the tenant received proper legal notification. They will also consider any affirmative defenses raised by the tenant, such as habitability issues, retaliation, or discrimination. For example, if a tenant claims you failed to maintain the property, and they have documented evidence like maintenance requests or photos, the judge might rule in their favor or reduce the amount of rent owed, effectively granting them a partial victory. A typical UD trial in California can last anywhere from a few hours to several days. Your attorney fees for a contested trial can range from $3,000 to $7,000. And if the case is complex or involves multiple court appearances, it can easily exceed $10,000 to $15,000. Compare that to offering cash for keys, a one-time payment of $1,000 to $3,000 for the tenant to vacate voluntarily. In many situations, it's a financially superior option, allowing you to regain possession faster and minimize your losses. Even after you secure a judgment for possession, your job isn't over. You cannot physically remove a tenant yourself. That's illegal and will expose you to significant liability. The final step is the sheriff's lockout. You must obtain a writ of possession from the court, which is then delivered to the sheriff's department. The sheriff will post a 5-day notice to vacate on the property. After those 5 days expire, the sheriff will physically supervise the lockout, changing the locks and ensuring the tenant vacates. This process, from judgment to actual lockout, typically adds another 7 to 10 days. During this time, the tenant is still occupying your property, and you are still losing rent. Furthermore, you are responsible for storing any personal property left behind by the tenant for a specified period, typically 15 days, and following strict notification procedures. Failure to properly handle abandoned property can lead to further legal complications and financial penalties. For example, if you improperly dispose of a tenant's belongings, they could sue you for damages, adding another layer of cost and headache to an already expensive process. Consider the cumulative effect. 3-day notice, 3 days, plus UD filing and service 7 to 10 days, plus tenant response 5 to 10 days, plus court scheduling and trial 20 to 45 days, plus writ of possession and sheriff lockout 7 to 10 days. You're looking at a minimum of 45 days and more realistically, 60 to 90 days from the moment you serve notice to the moment you regain possession. Each day is lost income. The best eviction is the one you never have to file. Prevention is not just cheaper, it's practically free compared to the alternative. Your first line of defense is rigorous tenant screening. This means going beyond a simple credit check. Verify income, contact previous landlords, not just the current one, and conduct thorough background checks. Look for patterns of late payments, previous evictions, and criminal history. A tenant with a history of evictions is a massive red flag. For example, a comprehensive background check and income verification might cost you $50 to $100 per applicant. This minimal investment can save you thousands. A tenant whose income is less than 3 times the rent is a higher risk for default. If a tenant has an eviction on their record, even one from 5 years ago, statistically, they are far more likely to be evicted again. Don't rationalize it. Once a tenant is in place, early intervention is key. If rent is even 1 day late, communicate immediately. Don't wait. A proactive phone call or email can often resolve minor issues before they escalate. If a tenant communicates financial hardship, explore options like a payment plan, but always get it in writing. Document every interaction, every notice, and every payment. This meticulous record-keeping is your armor if an eviction becomes unavoidable. Ignoring a missed payment for 2 weeks because you don't want to bother them can easily turn a $500 problem into a $5,000 problem. Recap: California eviction process is a financial and time sink. You're looking at 60 to 90 days from notice to lockout. Attorney fees for a typical contested eviction will run you $3,000 to $7,000, and if it gets complicated, easily up to $15,000. Your best defense is a strong offense, rigorous screening, and immediate documented intervention. Sometimes offering cash for keys minus $1,000 to $3,000 is the most financially prudent choice to avoid prolonged litigation. Don't let a bad tenant bleed your investment dry. Powered by LeaseBase Intelligence.